Discriminatory conduct. The Civil Rights Act of 1866 and its amendments. The original Civil Rights Statute was passed shortly after the Civil War to support the 13th Amendment. It gave non-whites the same rights under the law as whites. Title VII in the Civil Rights Act of 1991. The broadest anti-discrimination statute is the 1964 Civil Act together with the Civil Rights Act of 1991 Amendment. Title VII applies to employers, labor unions, apprenticeship committees, employment agencies, and federal, state, and local governments. Discrimination defined under Title VII. Discrimination exists according to the Supreme Court if there was disparate treatment of the protected class. If an employment policy resulted in the treatment of employees in the protected class differently, the result is discrimination. Disparate impact versus disparate treatment. Disparate impact is a term used when the plaintiff challenges the policies of management as being discriminatory towards a group of employees who are members of the protected class. Disparate treatment is a term used when less than the entire class is affected by discrimination. Affirmative action. The definition of affirmative action: a remedial action initiated by an employer to improve work opportunities for protected classes considered to have been denied employment opportunities because of past discrimination. Implementation. Make a good faith effort to improve the number of protected class individuals in the underutilized job categories. Affirmative action. Social justice or reverse discrimination. Could affirmative action be discrimination in itself? Harassment in the workplace. Harassment is giving an individual unwanted attention or just plain intimidation. Hostile environment. Hostile environment is workplace categorized by discriminatory antagonism, opposition, or harassment. Whether hostile environments exist must be evaluated on a case-by-case basis. Absent tangible employment action, allegation of sexual harassment are considered to be hostile work environment cases. This is an example of sexual harassment. A man touching a woman's shoulders or vice versa, any kind of unwanted contact is certainly an example of sexual harassment. Age Discrimination in Employment Act. The Act forbids employers with 20 or more employees to make employment decisions based on a person's age when that person is over 40 years old. It invalidates compulsory retirement for pension plans in the private and public sectors. It authorizes a jury trial of any issue of fact. It expressly authorizes employers to discriminate against older employees under certain circumstances. Punitive damages. Punitive damages awards. Originally, the courts were reluctant to allow punitive damages under the Age Discrimination Employment Act. The Civil Rights Act of 1991 amendment to the ADEA allows punitive damages under certain conditions, but imposes a cap of $300,000. Avoiding litigation. Avoiding lawsuits. Employers must be proactive in monitoring for potential discrimination problems and developing practices and policies to avoid the litigation of discrimination complaints. Litigation over employment issues can be extremely expensive and time-consuming. Works cited: John Remington, Richard Heiser, Cyrus Smythe, Kenneth Sovereign, The Discriminatory Conduct, Human Resources Law, 2012, page 22 through 58, 27 July 2013. Reference from Google Image.